Here, welcome everyone. My name is Tom Scriven. I head the Denver office for RPCK, which many of you know us in a variety of settings. We're an international law firm representing leading impact funds, investors, entrepreneurs, and others in the impact space. I'm joined on today's call by Josh Teitelbaum, Aaron Bork, and Chintan. Josh and Aaron will be joining me in presenting on the SEC's new rules. They're joining from our New York office. So the purpose of today's call is to dive into specific aspects of the SEC's recently enacted private fund advisor rules. Today's session will be focused on rules that apply to registered investment advisors. This is the second of two sessions. A previous session was focused on the rules that apply just to exempt reporting advisors. That recording is available upon request. You can check that out. You can also check out our bulletins that the RPCK team has recently published. Those are available on our website. They review the rules and are hopefully a helpful resource as you begin to prepare for compliance with the rules. As we begin, I remind you to submit your questions either in the chat or in the Q&A feature. If you do submit questions, particularly in the chat, I encourage you to remove identifying information so that you can keep your that information confidential and submit questions in an anonymous way. Before we dive in to a discussion of particular aspects of the rules, I think it's helpful to talk about some of the context for the rules, particularly in light of the SEC's historical approach to regulating private funds and their advisors, because certainly these rules represent a significant change in the SEC's approach. Historically, private funds were largely subject to disclosure requirements, but were otherwise subject to few regulations that expressly prohibited or restricted how private fund advisors engage with, particularly with investors in private funds. There was not much by way of regulation as to how private fund advisors would interact with the investors in the funds themselves, because the fund was seen as the client of the advisor. Now, however, we're seeing obviously a significant change reflected in these rules. So much of the freedom that advisors typically had with respect to, say, negotiating side letters, specific preferential terms for particular, usually larger institutional investors and anchor investors, the SEC now has said we care about how those negotiations occur and the rights that other investors, other smaller investors in particular, have with respect to their investments in private funds. So many of the practices that have been fairly commonplace and are commonplace in the industry are subject now to a significant regulation. And we see those regulations in several categories. Those that apply to all advisors, whether they're registered or not, fall within two categories: restricted activities and rules governing preferential treatment. So the restricted activities rules regulate the charging of regulatory fees and expenses to a fund. They also reduce the amount, regulate how a private fund advisor treats GP clawbacks, particularly reductions of amounts that are returned to investors pursuant to a GP clawback provision for amounts that are due for taxes. And then the restricted activities rules also apply to allocations of fees and expenses related to portfolio investments of a fund on a non-pro rata basis when an advisor manages multiple funds or other clients that are invested in the same portfolio company. In most cases, the rules don't contain an outright prohibition, but permit the subject activity subject to disclosure or disclosure and investor consent. So still there's at least in theory, some freedom to continue to engage in at least some of these activities, but there's much more that's required in order to be able to do so. The second set of rules are the preferential treatment rules. These prohibit or require disclosure of, again, practices that have become commonplace, such as granting redemption rights to certain investors, or granting preferential information rights or other preferential economic rights to investors. So we'll dive more deeply into what those rules entail and some of the implications of those rules. And then there are other rules that apply just to registered private fund advisors. These include the quarterly statement rules, the audit rules, and the rule governing advisor-led secondaries. There also is a requirement that the registered private fund advisors update their books and records, policies to comply with the rules, and that they, along with all registered advisors, whether they advise private funds or not, that they document their annual review of the adequacy of their compliance policies and procedures to ensure that they are sufficient to ensure compliance with the rules. So that's a high-level review of a lot of content that the SEC has put out. If you've seen the release that the SEC put out to accompany the rules, it's about 625 pages. So there's a ton of content there, and that's just indicative of what compliance is going to look like for RIAs as we approach the compliance dates for these rules. What are those rules? What are those compliance dates? They are the effective date is November 13th. So we're coming up on that, but that is not the date that most of the rules become effective. The compliance dates run from the effective date, either 12 months or 18 months, depending on which rule we're talking about and the assets under management of the private fund advisor. Those with $1.5 billion in AUM, in some instances, have a shorter period, that 12-month period for compliance. So that would be September 14th of 2024. Otherwise, the compliance date is March 14th, 2025. That sounds like a long way out, but given the significance of compliance with these rules and what that entails, we highly recommend that advisors begin thinking about what steps they need to take to begin complying well in advance of those deadlines. As you may have noted, there are grandfathering provisions so that certain rules don't apply to funds that have commenced operation before the applicable effective date. Those provisions are fairly limited, however, and we'll discuss instances in which those grandfathering provisions apply to particular rules we talk about later in the conversation. As a final introductory comment, I'd be remiss not to mention the lawsuit that's been brought by 6 industry associations in the Fifth Circuit Court of Appeals, challenging the SEC's authority to issue the rules. We're obviously tracking the outcome of that litigation. It may mean that certain rules don't go into effect, but obviously there's a lot of uncertainty there. So I don't think any of us should hold our breath or hold off on starting work to prepare for compliance while awaiting the outcome of that litigation. Certainly something to follow, but until there's a definitive decision in that case, we recommend that advisors can continue to prepare for compliance with the rules. So with that introduction to the rules and some context for the rules, we'll turn now to a more in-depth conversation of particular rules, and my colleagues and I will now consider specific implications. We'll start with Aaron, who will discuss rules, the implications for existing LPAs and other governing documents, including side letters that may have been negotiated or will be negotiated with investors prior to the compliance dates for the rules. So over to you, Aaron.
Thank you, Tom. So as Tom alluded to, my comments today are really more geared towards process than towards the actual content of the rules. Every fund manager, whether registered or not, is going to have to go through a process over the course of the next year to year and a half of developing a game plan for ensuring that your documents are compliant with the rules and figuring out when and how to update your documents and what sorts of updates are required. And that's going to be a very fact-specific analysis for each advisor based on the size of your business, how many funds you have, et cetera. So understanding that's going to be a challenging process, what I'm trying to do with my comments today is help to provide a framework for how I would think about going about making those decisions about updating your documents. And I'm thinking of it in terms of a series of questions that I'll go through. First, of course, is determining what scope of rules apply to you, which is a question of whether you're a registered investment advisor or an exempt reporting advisor. This webinar is about registered investment advisors, so I'll assume everybody participating is in that category. The next question that I think I would be asking myself is, what is the current status of each of the funds that my firm manages? For purposes of this discussion, I am ignoring funds that hold their initial closing after the applicable compliance dates, because those funds clearly will need to be, their governing documents will need to be compliant with the rules when they have their initial closing. I'm talking about funds that hold their initial closing before the applicable compliance dates. And within that, I see two broad subcategories. So the first category is funds that have already had one or more closings as of today. Let's say that you start to develop your game plan today and you're mapping out the funds that you currently manage. Funds that, so this is funds that already have an effective LPA or other governing document that's been signed. Under the grandfathering clauses of the rules, these funds will not be required to amend their fund documents solely to bring them into compliance with rules that are eligible for legacy status. But they will need to amend their documents to bring them into compliance with rules that are not eligible for legacy status. And I do think one thing that needs to be considered at that time is, if you're amending your documents anyways to make them compliant with rules that are not eligible for the legacy status, should you just update them at that time to bring them into compliance with the rules that are eligible for legacy status? And I'll talk a little bit more about legacy status later. So fund managers are going to have to consider when to enact these amendments. In our view, given the lengthy period of time before the applicable compliance dates, and also the significant amount of time it will take fund managers to analyze their documents and develop their game plan, and also the likelihood that the SEC will eventually release guidance clarifying vague elements of the rules, we think fund managers would be wise to take a wait and see approach with respect to actually amending the fund documents. I should caveat that by saying that you should not take a wait and see approach to developing your game plan and deciding what you're going to do. That you should start, as soon as possible. But we do think that it would make sense as a practical matter to set a reminder for yourself 1 to 2 months, let's say, before the applicable compliance dates. And if in the meantime, the documents of your funds that already have existing effective LPAs need to be amended for any other reason, like, for example, to reflect terms agreed with LPs in a subsequent closing, you can use that natural opportunity to make the amendments to your documents necessary to bring them in line with the rules in advance of the compliance dates. If no other natural opportunity arises to amend your fund documents prior to the applicable compliance dates, then we'd recommend that you start working on amendments to the fund's documents 1 to 2 months, probably closer to 2 months to be on the safe side, before the applicable compliance dates. So that's how I would think about, funds that as of today already have an effective LPA in place. Then there's another category of funds that are currently being negotiated or that begin fundraising prior to the applicable compliance dates, but have an initial closing also prior to the applicable compliance dates. I think the analysis there is more nuanced and fact specific. So I think, there are basically two options. One would be to proactively prepare a fund's documents so that they're compliant with the rules prior to the applicable compliance dates. The other option would be to prepare the fund's documents without regard for the rules at this point in time, and then amend the fund's documents prior to the applicable compliance dates to bring them into compliance. And that'll probably depend a lot on, where the fund is in its negotiating process right now. So for a fund that's early in its negotiating process and that has a significant runway to closing, I would anticipate most fund managers will probably conclude it's easier to just prepare the fund documents in the first instance so that they're compliant with the rules, rather than having to amend them a year from now to bring them into compliance with the rules. It seems doubtful to me in most circumstances that a fund manager would conclude that the hypothetical benefit of having documents that are not compliant with the rules for a period of, let's say, a year would outweigh the cost of having to amend the fund's documents later to bring them into compliance. But there also is a category of funds that have been extensively negotiated, are close to reaching an initial closing, and where fund managers might be loath to reopen points that have already been agreed. And in that case, you might prefer to close on documents that are not fully compliant with the rules, with a view to amending them to bring them into compliance prior to the applicable compliance dates. So that's an analysis, obviously, that each fund manager will have to make for itself, taking into account its facts and circumstances. But those are kind of two broad categories that I would envision in terms of putting this all into practice. The other thing I'll note, although I haven't seen empirical evidence yet of this in my own practice, is that fund managers might find that prospective investors begin to alter their negotiating positions and pressure fund managers to agree to terms that are compliant with the rules in advance of the applicable compliance dates. The LPs are obviously privy to all the same information that the GPs are, and clearly the SEC has laid out what they think is the right position on all of these things. And so I could imagine that as an LP, I might want to use that as leverage as a negotiating position. Okay, so a few other relevant questions that I think others may have on their minds. One is, do I need to update my fund's documents to bring them into compliance with the rules if in practice I actually do comply with the rules? And so the point I'm getting at here is that the rules govern the actual behavior of private fund advisors. They don't say you have to bring your fund's documents in line with the rules. So, for example, they don't say that fund documents have to provide for GP clawback to be net of taxes. Instead, they prohibit private fund advisors from actually reducing the amount of clawback by taxes unless they report to investors the pre and post offset amount. We would imagine that in most circumstances, fund documents won't have language that expressly requires fund managers to take actions that violate the rules, although obviously, if that's the case, that needs to be changed. So we could imagine a theoretical argument that if a private fund advisor is reluctant to incur the time and effort and expense to amend the fund's governing documents and collect investor consents, that you could take the position you don't need to update your fund's documents as long as you actually do comply with the rules in practice. And there may be some merit to that position. I think, as a practical matter, we would strongly advise any client in almost all instances to amend their fund's documents as necessary to bring them into compliance with the rules. In particular, I would see two significant risks of not aligning fund's documents with the rules. One would be that having fund documents that don't align with the rules is likely to increase the chances of inadvertently violating the rules. That seems obvious. And in the event of an SEC exam, funds documents that don't align with the rules might raise a red flag for regulators and cause them to apply greater scrutiny to the fund manager's practices. So I think it would be risky to not update your fund documents, but I can imagine that there could be fringe cases where the cost of amending a fund's documents is not justified by the potential risk mitigation benefits. So that could be the case, for example, where a fund is near the end of its term, any misalignment between its documents and the rules is minimal, and the fund manager has adopted clear policies and procedures to ensure compliance with the rules. So just as an example, we've talked about the rule requiring that clawback not be GP clawback not be offset by taxes without disclosure. You can imagine a fund that has an LPA which provides that the clawback will be net of taxes, and that fund is maybe in its 10th year and it's close to its dissolution date, and the rule and the compliance date passes. A fund manager might conclude in that circumstance it's not worth it to update my fund documents to make sure that they're consistent with the rules. Maybe there's another pathway in that kind of a situation to provide a notice to your investors that, look, notwithstanding what our LPA says on this point, this is the approach that we are going to take in order to be compliant with the rules, and it's beneficial to you as limited partners. That's a limited example where I could see that maybe you wouldn't go about amending your fund documents to bring them into compliance with the rules. But again, we wouldn't encourage, taking that lightly. Another point just to quickly address is obviously we would recommend, updating your policies and procedures to reinforce compliance with the rules. That would be especially relevant if you had fund documents that, as I just mentioned, didn't strictly require compliance with the rules. And then the last point is about legacy status. So just to reiterate the rule around legacy status, certain limited pre-existing contractual commitments contained in fund documents that have already commenced operations as of the compliance date will be eligible for legacy status and don't need to be updated to bring them into compliance with the rules, provided that such commitments were made in the private fund's governing documents. Those governing documents were entered into prior to the applicable compliance date, and compliance with the rules would require an amendment to those contractual commitments. So I think I would just make a word of caution there not to read the legacy status too broadly or as carte blanche to not comply with the rules with respect to the ones that are subject to legacy status, in particular because the legacy status or the exemption from compliance, I should say, only applies if compliance with the rules would require an amendment to your contractual commitments. So you could imagine all kinds of scenarios where your fund documents might on their face conflict with the rules, but that doesn't prevent you from complying with the rules. So a simple example would be if your fund's documents require you to provide investors with quarterly statements within 60 days after quarter end, that doesn't preclude you from providing quarterly statements within 45 days after quarter end, as the quarterly statement rules require. So we anticipate, obviously that the SEC will provide additional guidance before the rules go into effect, and hopefully will clarify some of these points. But to us, it seems that the legacy status should be viewed somewhat skeptically in terms of how much leeway it gives you to be non-compliant with the rules. And just to reiterate one final high-level takeaway, obviously this stuff is complicated. And so we reiterate that you should begin your planning process now and consider your facts and circumstances carefully and to figure out what your game plan is. Thank you. With that, I'll pass it back to Tom.
Thanks, Aaron. So now we want to turn the discussion to consider what are the implications of the rules for, say, your discussions with investors of side letters or other discussions in which you may negotiate specific preferential terms for investors or adjustments to the LPA, to other documents where in particular investors are seeking some beneficial term for themselves. Before we turn to that, Josh is going to lead that discussion. I'll highlight a few aspects of the preferential treatment rules because that certainly is relevant to that discussion, and highlight a few points that advisors are maybe thinking about or have questions about as you consider compliance with these rules. So the preferential treatment rules have a few different components. They apply to all advisors to U.S. private funds, so exempt reporting advisors, RIAs. They don't apply, as is true for all the rules, to offshore advisors who are advising offshore funds, even if those offshore funds have U.S. clients in them. The rules also don't apply to securitized asset funds, so it's a a narrow class of funds for whom the rules don't apply to the advisors to those funds. But otherwise, if you're a private fund advisor, the preferential treatment rules apply. What are those rules? The rules have a couple components. One pertains to preferential redemption rights. So you cannot grant preferential redemption terms to an investor in a private fund or a similar pool of assets that the advisor reasonably expects will have a negative effect on other investors in that fund or other similar pool of assets managed by that advisor or its related person. So here the SEC is looking broadly and saying if there are alternative investment vehicles, if there are maybe even if there are other funds managed by that advisor that is, say, one of those funds is a successor fund, you have to look at the impact of granting a redemption right to, say, an investor in Fund 1 on investors in the successor fund, Fund 2, or alternate investment vehicles that invest alongside or are used as another way to pool capital for investments. You have to consider what are the impacts of granting that redemption right on all of those investors. And if the advisor reasonably expects that grant of a redemption right to some but not all investors would have a negative effect on those other investors, then that would be prohibited absent an exception. The exceptions are very narrow. So if an investor has a particular if the investor is subject to certain laws, regulations, or orders of a government, then that requires that the investor have a right to require the fund to redeem its interests. Say it's a pension fund that has to that is required to exit if certain circumstances arise, then a redemption right can be granted in that instance. But that exception is narrow and does not apply to internal policies and procedures of an investor. So one of the questions that has arisen is whether if a private foundation indicates that it needs a right to have its interests redeemed in the event that its investment in the fund will no longer qualify as a program-related investment, is that a redemption right that is subject to this exception? And it's not clear that it would be because a private foundation isn't required by law to have a redemption right if its investment no longer qualifies as a good PRI. There may be the case that a case that could be made there, but there's still some uncertainty there for sure. Another exception to the rule against providing investors a redemption right is if you offer identical redemption rights to all investors. They have to be on the same terms and can't be subject to, say, an investor having a higher commitment level than a commitment level over a certain threshold, for example. So if all investors are granted, say, a redemption right in the event that the investors are paying, say, a higher fee, then that would be acceptable because all investors are subject to that condition. But otherwise, preferential redemption rights would not be permitted. The preferential treatment rules also apply to other terms beyond redemption rights. For example, to information rights that a fund advisor may give to certain investors. So the question here is, well, what rights are we talking about? The rule applies only to information rights that if granted to particular investors, would have a material negative effect on other investors who are not entitled to to receive that same information. This is particularly relevant where there are redemption rights. So if you grant information to particular investors, say about an incident at a portfolio company, then that grant of information may trigger other investors to exercise their redemption rights, and that could have a negative effect on others who don't have access to that information to inform their exercise of redemption rights. Now, if investors don't have really any way to act on that information that they're selectively entitled to, then perhaps an advisor could make the determination that they don't see how there's a reasonable expectation that selective disclosure of information would have a material negative effect on other investors, and so they can grant that right to selective information. But that is the kind of analysis that would need to be conducted. Similarly, you might think about what are the implications of this rule for impact reporting that a particular investor requires of the fund. And here again, the analysis is by granting selective information rights, even with respect to impact, would that have a material negative effect on other investors in the fund? And again, you might consider a circumstance where, say, rights to be informed of an environmental spill or an incident involving, say, the mistreatment of employees by a supervisor. If an investor has rights to receive that information, and they also say have a right to require the fund to redeem them in the event of some of these adverse environmental or social incidents, and that investor has rights, exclusively, and other investors aren't granted that same right, then there may be a case to be made that providing that selective right to information could have a negative effect on other investors, because one investor may exercise their redemption right upon hearing that news to the adverse kind of effect to other investors in the fund. So that's the kind of analysis that needs to be done. We'll turn now to a consideration of what does it mean for a fund advisor to have to treat investors equally with respect to redemption rights, information rights, and what are the implications for negotiations with investors, negotiations of side letters, or other negotiations that a fund advisor may have with prospective investors. And I'll turn the floor over to Josh to lead that discussion.
Hi, everybody. So we're continuing to talk about the preferential treatment rule. And as Tom mentioned, it really breaks down into two separate components. In the first component, the SEC is focused on specific kinds of preferential treatment that are given to investors in a fund, and has said these are important enough that we want to prescribe the way fund managers can grant these preferential terms to investors in the fund. And those are redemption rights and preferential rights to receive information about the funded portfolio companies. But the preferential treatment rule also applies to all other sorts of preferential treatment, read side letter benefits that sponsors give to fund investors. So in those instances, the SEC hasn't said that we're going to prescribe the way that you grant or the circumstances under which you can grant these preferential terms to investors, but we are going to require that you disclose those preferential terms to investors. So the SEC is basically taking out of the hands of the fund manager and the investors who typically contract around these sorts of disclosures. I mean, you get an MFN and you get the right to read side letters and see what preferential treatment other investors have received, or you don't if you either don't negotiate an MFN or you don't really have the leverage to see other side letters based on the level of your commitment, for example. But the SEC is saying we're taking this decision out of the hands of investors and sponsors, and we're going to mandate the situations under which sponsors have to disclose to investors the preferential treatment terms under side letters that are given to other investors. Here, the SEC has basically divided up the world into two different types of investors. You have to give certain disclosure to investors who are prospective investors. So in this case, before they even invest in your fund. In the second case, you have to give disclosure, and the disclosure that you need to give is slightly different here, to investors who are actually already admitted to and investors in your fund. So these disclosure requirements have the potential to significantly change the way in which fund managers negotiate with and provide information to their investors. And it's going to impact the MFN process, negotiations with investors, how closings are structured, and other interactions between investors and sponsors. So first, let's dive into the disclosure requirements for prospective investors. These are the disclosure requirements that are most likely to have the most significant impact on sponsor investor negotiations. So first, I'll lay out the requirements, and they're a little dense. So once I've done that, we'll break it down a little bit and dissect the requirements to understand really what's required of fund managers in terms of disclosure. So the preferential treatment rule requires fund sponsors must provide each prospective investor in the fund before they invest in the fund with a written notice providing specific information about preferential material economic terms that the sponsor provides to other fund investors. So first, let's talk a little bit about what must be disclosed to prospective investors. The sponsor is not required to disclose all preferential treatment that's being provided to other fund investors, but only preferential treatment that is related to material economic terms. Now, the SEC has said that they feel it's important for prospective investors to have access to certain information before they invest. The SEC is focused here on transparency and improving prospective investor bargaining power and negotiating power. So while the SEC hasn't provided an exhaustive list of what constitutes material economic terms, it's clearly not all terms or not all economic terms, these are material economic terms. They've said that this concept covers, at least, for example, preferential terms that go to the cost of investing, liquidity rights, fee breaks, and co-investment rights. Those are pretty clear-cut categories on which the SEC has spoken, but whether or not other preferential rights qualify as, quote, material economic terms is something that the SEC has said we're going to have to evaluate on a facts and circumstances and a case-by-case basis. The next question that's helpful to ask is, how must disclosure be given to prospective investors of these material economic terms? So the disclosure must be in writing, and that writing must provide specific information regarding preferential material economic terms that are provided to other investors. So first, it seems pretty clear from the SEC's release that generalized advanced disclosure in a PPM or in a limited partnership agreement won't suffice. You can't just talk about various categories of preferential treatment that you may or may not grant to folks in side letter in the ordinary course. What's required is specific information about preferential material economic terms that you actually provide to other investors. So for example, if you give an investor a discounted management fee in exchange for a large capital contribution, the SEC has clearly said that it's not sufficient to just say that you've given management fee discounts. Rather, the SEC expects specific disclosure on the amount of the fee, or if you give multiple discounts, the range of discounts that you give, but you need to be particular. As to the way you provide disclosure, you could provide redacted copies of side letters and let prospective investors read for themselves, or you could provide a written summary that specifically describes agreed preferential material economic terms. Next, what's important is when must this disclosure be given to prospective investors? And so here the SEC is clear that it must be provided prior to the completion of the investor's investment in the fund. So if you're in an initial closing situation, this is before the initial closing even occurs. The SEC hasn't specified any particular amount of time prior to an investment in the fund, but they have made it clear that the reason they're requiring advanced disclosure here to prospective investors is to provide important information to investors that the SEC expects will significantly impact investors' bargaining position. So it's clear that they expect the prospective investors will receive this disclosure of material economic terms sufficiently in advance of the closing so that they can take the information into account in evaluating, but more importantly, negotiating the investor's investment in the fund. I mean, here the SEC is looking to level the playing field, aggressively and affirmatively between sponsors and investors. So as you can see, this advanced disclosure requirement might provide an incentive for investors to seek to participate in the final closing of the fund, or at least later closings, because at that time they'll receive maximum disclosure around what material rights folks who've come before them have received. So market practice is going to have to develop to counteract this incentive and drive investors to be willing to participate in initial and earlier closings. For example, granting an MFN to investors participating in early closings can help counteract this potential issue. But MFNs, as you know, tend to be very limited and qualified, and they're not a substitute for this full advanced disclosure that the SEC is requiring, which would occur at final closings. So I could see market practice shifting so that typical MFN terms are modified, made more generous or more open, so that they would be more of an equalizer between receiving an MFN at an earlier closing and having a full disclosure of all economic terms granted at a later closing. And maybe this will push folks to invest at earlier closings. Next, what's helped to discuss is which prospective investors must be given this disclosure. The answer is all prospective investors. So unlike an MFN, where sponsors can stratify MFN rights by commitment level or participation in an earlier or later closing, the SEC says everybody has to get this disclosure. So if you're negotiating with a $250,000 investor and a $2.5 million investor, both the $250,000 and the $2.5 million investor have to receive the same disclosure about each other's and everyone else's material economic terms. So this raises potential investor relations issues and questions. Previously, if you're investing $250,000 in a fund, you might not ask for a side letter. You might not even be aware of the sorts of preferential terms larger investors might be asking in the same closing. Now these smaller investors will have access to information about preferential material economic terms being granted to other and likely larger investors. So it remains to be seen is what they'll do with this knowledge and how this will impact negotiations. But they'll now have unprecedented access to the terms being made available to lots of other investors who aren't similarly situated. Now, the important question is how will this advanced disclosure requirement of material economic terms impact negotiations with prospective investors? So originally, when the advanced disclosure rules were proposed by the SEC, commenters objected and said that this will make it impossible to hold closings. I mean, how can an advisor negotiate with folks and come to a closing and finalize side letters if they're required to continually disclose material economic terms agreed with other investors? They were worried about, quote, a repeated cycle of disclosure, discussion, and potential renegotiation. So the SEC was aware of this, and the SEC said that we think it's more important or as important that these prospective investors receive this material economic term disclosure than it is to worry so much about how sponsors will deal with organizing closings. So market practice is going to have to evolve to impose rational behavior and allow for orderly negotiations and closings. Sponsors and investors are going to have to align on a process that allows for fund closings to occur in a rational way, notwithstanding advanced disclosure requirements. If investors are continually retrading and renegotiating side letters based on updated disclosure of these material economic terms before closing, then the parties run the risk of getting stuck in a perpetual loop of negotiations without the ability to finalize documents for closing. That's obviously bad for sponsors, but it's also bad for investors looking to profit from investing in funds, and even worse for impact investors looking to achieve impact by investing in those funds. So market practice is just going to have to figure this out to some extent. As I've noted, the SEC's goal is to give prospective investors greater access to information, to give them greater bargaining power in negotiations with sponsors. So to some extent, this is the outcome the SEC is hoping for, notwithstanding that it may take some time for the market to absorb these requirements and to rationalize a process for negotiating side letters and holding closings. So that's how the rule applies to require disclosure for prospective investors. The rule also covers disclosure for existing investors in your fund. First, sponsors of illiquid funds. So these are funds that don't feature redemption rights regularly, like closed-ended venture capital and private equity funds, must give disclosure to every investor in the fund of all preferential treatment the sponsor has given to any investor in the fund as soon as practicable after the end of the fund's fundraising period. So after the fund is finished holding closings, you have to disclose preferential treatment to everybody. In the case of liquid funds where there are regular redemption opportunities, this requirement has to be managed for each investor after that investor closes his investment in the fund. So they have to have the playing field leveled pretty quickly after their investment because redemption rights and liquidity come into play. So let's just dig into this a little bit. Unlike investors who are prospective investors who must receive only material economic terms disclosure, existing investors in the fund get all preferential treatment given to any other investor disclosed to them after the fundraising period ends. Effectively, this means that all said side letter provisions will be disclosed to all investors in the fund. It's full transparency as to side letter provision. I mean, I suppose there's a universe in which there could be a side letter provision that doesn't constitute a preferential term, but that's more or less obviously the basis for side letters. Information identifying the limited partner receiving the preferential treatment can be omitted, so you can redact side letters or provide a summary on a no names basis. But unlike the typical MFN context, you can't limit disclosure because someone has a higher capital commitment than someone else, or because someone participated in an initial closing versus a later closing. Everybody gets disclosure of everybody else's preferential treatment. And then the question is, again, which investors? Similarly, here, the $250,000 investor gets the same disclosure as the $2.5 million investor. Full side letter transparency. So now the question is, how is this going to impact negotiations between the sponsor and investors? Because this is all on the back end and isn't before a closing and the fund has to occur, it's probably not going to affect negotiations around that particular fund. In other words, I mean, unless you've negotiated an MFN right to receive other people's side letters and then, receive beneficial treatment that they've received in other side letters, you won't have any rights to actually elect anybody else's side letter provision. You'll just receive a copy of the side letter. So for that particular fund, the impact is probably not very adverse to sponsors. But what the SEC is really looking to do here is level the playing field. And over time, as this disclosure is shared with folks who invest in fund, create a new breed of investors who are better informed, understand what's happening in the market and the sorts of beneficial terms that sponsors give to investors of various shapes and sizes and commitment levels, and level the playing field. So ultimately, this enhanced transparency and better informed investors are likely over time to just alter the dynamic and status quo between investors and fund sponsors. And some number of years from now, negotiations and what's customary and typical may look very different. Finally, there's one additional element of disclosure to existing investors, and this is an annual disclosure. So on an annual basis, you have to disclose to all existing investors in your fund any preferential treatment you've granted since the last time you made an annual disclosure. For closed-ended venture capital and private equity funds, this really likely means that at the end of your fundraising period, you'll make a disclosure to all of your investors of all preferential side letter treatment. And then at the end of the next year, you'll probably make the same disclosure or rely on the previous disclosure. And then because no additional closings are happening, it's pretty rare that additional side letter relief is granted. So likely the annual requirement won't be required because there won't be any further side letter provisions granted to investors after the final closing. So there shouldn't be much additional ongoing compliance required. I think that's about it on disclosure of preferential terms. So I'll bring it back to Tom.
Thanks, Josh. So now I want to cover some of the other rules that are applicable to RIAs, highlighting a few of the rules that will have significant implications for how advisors are interacting with investors in the fund. One of these is the quarterly statements rule. So obviously, advisors are already providing reporting to their investors, but the SEC is saying we want more information, and that information typically includes information that advisors are not currently providing to investors, at least across the board. So in these quarterly statements that will be due after the compliance dates we previously discussed, the advisors will need to within 45 days of the end of a fund's first 3 fiscal quarters and 90 days after the end of each fiscal year of the fund, provide substantial disclosures relating to several topics. One of the significant areas pertains to fees and expenses of the fund, including those fees and expenses that relate to compensation that the advisor is entitled to, and all fees and expenses that are allocated to or paid by the private fund during the reporting quarter. And then in each case, the fees and expenses that are disclosed must be disclosed before and after any rebates, offsets, waivers, etc. So they'll need to be broken out in that way. And then to the extent that there are carryovers from one quarter to the next of any offsets or rebates to a subsequent period to reduce future payments or allocations that are made to the advisor or its related persons, there would need to be a disclosure of those carryovers as well. So here an example would be, say, placement agent fees that that the advisor is responsible for because the fund is not going to pay those fees for capital raising. Those fees may be subject to offset so that the management fee is offset based on the placement agent fees, and that may be done over time. So you have a carryover from one period to the next of those fees and their offsetting of management fees. So that carryover would need to be reported in the quarterly statement. So that's one kind of implication of that rule. Also, if an advisor is entitled to compensation from any portfolio company, that compensation also needs to be disclosed in the quarterly statement. So here the SEC is both in the proposed rules, which had a slightly different take on compensation from portfolio companies that was more aggressive and less favorable. Here the SEC is weighing in favor of rather than prohibiting compensation from portfolio companies in certain instances to a disclosure-based regime, so that the compensation paid by portfolio companies is disclosed to investors. The SEC wants, again, as Josh made clear, the SEC wants investors to have more information in really across the board about, in this instance, what fees are being charged, the implication of how any fees may be offset by other obligations of the fund, and reporting that on a quarterly basis. So investors have that information very soon after the fund is responsible for those fees and expenses. The quarterly statements also must include detailed performance information, which varies. The information is reported based on specific metrics that the SEC has identified, which vary depending on whether the fund is an illiquid fund or a liquid fund. So this will be particularly interesting for private funds that have illiquid strategy. They will need to measure the performance of their portfolio for investments that may not see an exit for a very long time, and there may not be other rounds that those portfolio companies are in the midst of to make performance to make valuation determinations. So funds will need to be thinking about, well, how do we consistently report the performance of our portfolio in terms of IRR, MOIC on net and gross terms to comply with the SEC's requirement that information be disclosed on a quarterly basis. So significant lift there. And then there's more to what is involved in those statements, but those are a few of the more significant elements of what will be required in those quarterly statements and how they may play out for how those requirements may play out for particular funds. There also is a requirement that all private fund advisors have their private funds audited on an annual basis, that those audits be conducted in accordance with US GAAP, and the audits be performed by an independent public accountant registered with the Public Company Accounting Oversight Board. So there's that higher standard that applies to the auditors. So that will increase the cost of conducting audits. Many private funds are already having many private funds are already being audited, but not necessarily by a PCAOB certified accountant. So there'll be more demand for those accountants, and that is likely to increase the cost of obtaining audits. The audited financial statements need to be delivered to investors in the private fund within 120 days of the end of the fund's fiscal year. Certainly in the impact space, particularly where you're talking about emerging markets, we often see that private funds, LPAs, provide for the delivery of year-end financial statements, audited or not, within some longer period of time, or at least the LPA provides the advisor with the opportunity to deliver financial statements on some longer term time horizon if, say, information from portfolio companies is not available to complete the audit within that 120-day time period. So while that is, a significant amount of time, we can envision that would still be a challenge for certain advisors to comply with that deadline. So the next rule that's applicable to registered investment advisors that I want to touch on pertains to advisor-led secondaries. So generally, if an advisor is going to lead a secondary transaction involving the sale of interest in a private fund, the advisor must obtain and distribute to investors in the private fund a fairness opinion or evaluation opinion from an independent opinion provider. And along with that opinion, disclose to fund investors in writing any material relationship the advisor or its related persons has with the provider of that fairness opinion or that valuation opinion, so that investors are aware of that potential conflict of interest. So the question is, well, what is an advisor-led secondary? Generally, if the advisor is leading or initiating a process for investors in the fund to be able either to liquidate their interests or to essentially carry over their interest in, say, Fund 1 to a continuation fund, that would be an advisor-led secondary that's subject to these rules. In other, you may see a situation where, say, an investor is asking an advisor to facilitate a secondary transaction in which that investor is selling their interest to another investor. If the investor is initiating that process in essence and just asking for the advisor's support in, say, documenting that transaction and having it, reflected in the fund's records, then the rules would not apply, and the opinion, the valuation opinion or the fairness opinion would not need to be delivered to all investors in that instance. So that's the advisor-led secondaries rule is another rule, again, that applies to registered investment advisors. So at this time, now that we've provided a significant amount of content related to the rules, we certainly haven't covered all of the rules. There's some that we've only alluded to. I want to open up the floor to questions that you may have regarding the rules and how they may apply to your firm, or how you envision the rules applying in general. So please feel free to put those questions in the chat or in the Q&A box below. A couple questions we can get started on here. So let's see. So Josh, I'll direct this question to you. So with respect to the preferential treatment rules, what do you see as the impact of these rules on, say, a fund's ability to negotiate with specific investors to provide them a seat on the LPAC? And often relatedly, an investor may have rights to specific information on account of having a seat on the advisory committee, say to minutes of LPAC meetings, materials that are disseminated to LPAC members in advance of a meeting, or other information that naturally would be provided to members of an LPAC. So I'm curious what your thoughts are on the rule's potential implications for those rights.
So I think granting a seat on the LPAC, I would say, isn't a material economic preferential right. So it's not necessarily something that would have to be disclosed to prospective investors. It certainly would have to be disclosed to all investors as a preferential right at the appropriate time after the fund's fundraising period. I guess the question is whether or not it runs afoul of the prohibition on granting preferential information rights that might materially and negatively affect other investors. I think it depends a bit on the context. It's going to be a case-by-case analysis. As you discussed earlier, Tom, in the context of closed-end funds without really redemption rights or opportunities for liquidity, it may be less problematic because the SEC has said that presumptively having information about portfolio companies on a preferential basis is most likely not to materially and negatively affect other investors in the context of a closed-end fund. But I mean, the question is getting information in your capacity as or having a designee on the LPAC the same as having a material information right? I think we'll have to see how things develop and how folks look at this, but I would say that the conservative approach is yes, that whether you provide preferential information to someone by virtue of having an LPAC designee versus just a naked right in a side letter to receive updates or information, it's the same answer. So prophylactically, if you make a decision that if information available to an LPAC designee could materially and negatively affect other folks, then the answer would be you have to give everybody the same information or somehow sort of guard the information you provide to LPAC designees, which is obviously challenging. So I think this is one where we're gonna have to see how the SEC responds and gives further guidance and how things develop.
Yeah, it'll be interesting to see what happens if the broad dissemination of information actually could have a material adverse effect. Say certain investors have they have a connection to a competitor to, say, a portfolio company, and so a fund may want to withhold information regarding certain portfolio companies from certain investors who, say, are heavily invested and active investors in a potential or actual competitor. Is that a basis for withholding information that otherwise all investors should have a right to? It doesn't seem like the SEC has contemplated that or allowed for that withholding of information, but it seems a little strange to me that there's not some kind of carve out there for that situation.
Yeah, agreed.
So I'll ask another question of you all while you're on the hot seat. So what do you think about excuse rights? Would those qualify as material economic terms which must be disclosed prior to an investor's admission to a fund, if some investors are granted excuse rights and others are not.
It's tricky. It's certainly not something the SEC has spoken to specifically. I think it's certainly a preferential right that needs to be disclosed when you're disclosing to all investors. Whether or not it's a preferential economic right, I mean, it has, depending on how the fund is set up and what style waterfall it is and how you receive distributions based on your participation in sort of one or all investments, it can certainly have the potential to de-risk things for you in a way that it doesn't for other investors. So if, let's say, you have an excuse right and you request to be excused from an investment that turns out not to be a great investment, then sort of, you're weighting your participation in better investments versus worse investments differently than other folks. And so indirectly, I could see that it could provide an economic benefit. It might have something to do with the way that the excuse right is exercised in a particular instance and how it's framed and under what circumstances you could be excused. So, I mean, obviously these things come up in lots of different contexts inside letters. So I could see that the answer could be yes, but I could also see that the answer could be no. So it definitely has the potential, I would say.
Yeah, the SEC explicitly did not address that issue, to your point. So here we are guessing what the rule is.
Yeah, I mean, I would think, if you conclude that an excuse right is a material economic right, then obviously it's something that has to be disclosed to other investors before they invest. But usually those types of excuse rights are given to investors based on specific policy limitations or geographic limitations, for example, that are pretty specific to that investor. So like a development finance institution that can't invest in developed countries or something of that nature. So I would think that the knock-on effects or the ripple effects of disclosing that to other investors would hopefully be pretty limited. It's hard for me to imagine that an investor that doesn't have a similar policy-based prescription would say, now I demand that I get that same excuse right in my documents, or I won't invest. You know what I mean? So I wonder if the practical effects of that would be fairly limited.
I think that's right. I also think, though, that one thing I touched upon is that it's going to take some time for this stuff to all work itself out. I mean, there's a class of investors who invested in funds who previously weren't really exposed to like the panoply of different rights that are given to different kinds of investors, whether it's based on being a DFI or a foundation or having some commitment level. So there's going to be an education process that's going to have to occur between sponsors and investors, where now that everyone's going to see everything and advance see material economic rights, the sponsor is going to have to sort of delicately describe to investors, well, this is why it's being given, and this is why you can't have it. And there's going to have to be a principled discussion, again, to rationalize closings and not have people just asking for pie in the sky that they really shouldn't reasonably be entitled to, and sort of, right-sized negotiations and have expectations normalized. But that might take a while investors who are sort of, drinking from a little bit of a fire hose of new information sort of, digest and rationalize that information, and everything kind of regularizes.
Right. Then maybe we see a lot more incorporated in the LPA that otherwise would be inside letters, and it's kind of a take it or leave it approach. And here are the terms that you get if you're investing in the fund, and maybe there's some room for saying you get these rights if you participate in the first closing, but not the next. Obviously, that can't apply to, say, a redemption right, but other economic terms, maybe you provide, certain more favorable terms in an early closing, but you just put that all in the LPA and try to fend off multiple rounds of negotiations in advance of the initial closing.
Yeah, I mean, I could see that as a tactic to ease the process of having an initial closing without having too many investors sort of raising their hands and asking questions and demanding things in that sort of endless cycle that the commenters on the rule were warning about, where it becomes impossible to have a closing. I certainly see LPAs already, even prior to the existence of these rules, that have provisions that say certain investors may have limitations on the geographies in which they can invest, and they may be given excuse rights on that basis. And so that at least gives kind of fair warning and disclosure to all investors in the fund that that's a thing, based on a document that they're all reading. And then it probably becomes easier then at that point to disclose to them, hey, such and such other investor has this geographic limitation, and so they're availing themselves of that provision of the LPA. Like, that's something that another investor might just say, oh, okay, like, and not have to ask a bunch of questions or, explain things to them.
Yep. Okay, yeah. So another kind of related question here is, what does it mean for these rules to apply to a private fund and then similar pools of assets? So a redemption right cannot be granted to an investor in one fund if that would have a material adverse effect on other investors in that fund or in similar pools of assets. Similarly with preferential information rights, if granting those rights, selective information rights to an investor in one fund would have a material adverse effect on investors in not only that fund, but in a similar pool of assets. This rule has some potential broader implications than one might initially think on account of that application to investors in similar pools of assets. So what does it mean? What does similar pool of assets mean? Aaron, I'll toss it over to you to provide your thoughts on that.
I mean, I would have to read the specific language in the rule again to remind myself of the precise, things that the SEC has listed. But my recollection is that, it definitely includes alternative investment vehicles, parallel funds, successor funds, and then there's some language in there around that's actually quite a bit broader than what a layman's interpretation of the language might be, and it kind of refers to the possibility that a manager that has two funds that are sort of have similar terms but invest in different asset classes could theoretically be similar pools of assets. I'll invite either of you guys to sharpen my description of this if I'm getting any of it wrong.
No, I think that's right. So I think that it's clear that parallel funds, AIVs, those sorts of co-investment vehicles are definitely similar pools of assets. And you could see how giving a redemption right or an information right could negatively affect investors in those vehicles, even though they're not in the main fund. Because in that case, the same portfolio is being invested in, likely pro rata based on, commitments to a parallel fund. There are rules around co-investment vehicles having to invest on the same terms and exit at the same time as the main fund. So for all intents and purposes, like, all of these vehicles equal the main fund when you add them up together. So it makes sense. I agree that other funds managed by the same manager that might not even have the same strategy technically fall within the definition of a similar pool of assets, because the SEC is looking to cast a very wide net here. But then the operative question is going to be, how can a redemption right or an information right given to an investor in a fund or its satellite vehicles that invest in X materially and negatively affect investors in a different vehicle that are investing in Y? Or in a different geography. And, it just seems a lot more circumspect that a right given to investors in a fund is going to materially and negatively affect investors in a different fund that is investing in different stuff. It's possible, and you have to look at it because the SEC has given such a broad definition, but I think you're a lot less likely the further you go out from the fund and its satellite vehicles to find that the answer is that yes, other fund investors will be negatively impacted.
Right. So it's not just is the pool of assets similar? So you could say fund 2 is potentially a similar pool of assets, but then you also have to ask the question, is there material adverse effect that investors in, say, fund 2 would realize on account of what happens at fund 1 and the particular rights that are granted to investors there?
Sure. And I could see fund one and fund two yielding an answer of yes, because, there between follow-ons from fund one and initial investments in fund two, there may well be cross investments and co-investments in shared portfolio companies. But I mean, the SEC has said that if there are different strategies, different geographies, and there's no way they'd be investing in the same portfolio companies, there's still similar pools of assets. I mean, that's when you get sort of, far afield enough that hopefully the answer is like, I have to look at it, but it's not something to worry about.
And there are other tools in the toolkit with respect to the redemption rights in particular. And I mentioned it because it's one that I've had to kind of negotiate live already, to try to protect a fund sponsor from a situation in which your fund could potentially implode because you had to give the same redemption rights to every single investor, and then they all exercise their redemption rights upon the occurrence of some event, right? So there's different strategies to try to protect yourself against that. One of them is to try to set up, one of them is the first idea is to just push back on a redemption right completely and see if you can get an investor to yield on it entirely. But assuming that you can't do that, try to set up the redemption right in a way where the terms don't have a material negative effect on other investors in the fund. And that's something that our team has discussed quite a bit, and you can kind of come up with various arguments for why terms may or may not negatively affect other investors in the fund. I think at a minimum, you would want to say that a redemption price could be paid out through the issuance of a promissory note where the investor gets payments as and when it would have received distributions as a limited partner, so that you're not sucking cash out of the fund on the moment of redemption. Query where that cash is even necessarily going to come from. But that would be something that to me would have a material negative adverse effect. So that would be like a must-have if you're going to agree to a redemption clause. As we discussed amongst our team, there's still lots of arguments you can make for why any redemption might have a material negative effect on other investors. If it's a large enough investor and you're taking a large enough commitment out of the pool, then other investors are getting, there's less diversification in terms of the sharing of participation in the investments. The investor who's redeemed is no longer subject to LP give back to satisfy obligations of the fund, like indemnification obligations. So there may be certain structural ripple effects of a redemption that just have a material negative effect on other LPs, and that you can't really work your way around. The SEC just hasn't provided enough guidance to really know. So we all kind of have to operate, unless they provide more guidance in the coming months, in a realm of imperfect information about what would constitute a material negative effect or not. But let's say that, you conclude that doesn't apply, and that also that the investor doesn't have a particular law or regulation that they're subject to that would allow you to not give that preferential right, redemption right to other investors. The other things that I'm looking at is, are there ways that you can soften the provision before a redemption right comes into play? So can you maybe negotiate for a cure period, whatever the thing is that triggered the redemption right? You have some period of 30 days or what have you to cure the issue so that a redemption doesn't have to come into play. Can you convince an investor to agree to that the GP will use commercially reasonable efforts to help the investor transfer their LP interest in the fund instead of redeeming? So those are the kinds of things I'm looking at from a sponsor perspective in terms of how can we soften this provision for sponsor side clients and prevent a run on the bank situation where you've had to give the redemption right to everybody, something triggers it, and everybody wants to get out.
Yeah, thanks, Aaron. Some thinking that needs to be done to address what we see often in this space in terms of particular investors needing redemption rights or other special treatment that, if granted to everybody, may be problematic. Well, thank you, everyone, for joining us today, for your questions. There are a lot of questions about the rules that we continue to see. We're happy to schedule follow-up calls to answer those questions, to help you think through what compliance in any particular aspect might look like for your firm. We're available to answer those questions. And with that, we'll wrap up this session. And thank you all again for joining us today.
Thanks, everyone.
Thank you, everybody.